And there's Asher Anderson.
Yes, Asher's my assistant. He's just listening.
Okay. All right. And I think what was said today, I've got a motion to strike and or motion to dismiss the amended complaint, and also a motion to dismiss a corrected amended complaint. And then Mr. Klayman has filed opposition to defendant's motion to dismiss the corrected amended complaint. So whenever you're ready.
Yes,
I assume we can take both motions together, just hear all the argument together, I assume.
I think that's fine, Your Honor.
Okay.
Your Honor, we've prepared a bit of a PowerPoint just to run through it. It's super short.
Okay. However you want to proceed.
Can you see my screen?
I can.
Okay. So, Your Honor, the lawsuit was originally filed January 22nd of 2020. It stemmed on, as you will recall, 2 articles published to Wonkette, a newsy blog, one from June 26, 2019, and one from October 24, 2019. The plaintiff, Larry Klayman, sued for defamation pro se, defamation, and defamation by implication. We filed our motion to dismiss, a motion to strike, a motion to transfer the case to county court based upon the lack of jurisdictional amount. And on May 5th, 2021, the court issued an order dismissing the case and giving him 20 days to amend. Otherwise, the case would be closed by the clerk without further order. So we filed a notice of hearing to try to obtain the otherwise otherwise the case would be closed by clerk with further orders. We didn't receive anything. Ultimately, well, let me get into the court's order. We'll come back to that. So the court was reasoned and went through all of the First Amendment issues that our motion to dismiss brought out, and even more. And so the public figure status, the court went through the case law, even citing Klayman cases where Larry Klayman was the plaintiff, saying that Mr. Klayman should know he's a public figure because of all the litigation that he's had with it, and ultimately found that Mr. Klayman was a public figure. Then the court went into allegations of actual malice and said they were insufficient as a matter of law. Your Honor, wasn't unclear, was succinct, and established that this is not a case of actual malice. Well, where does that leave us? Again, the court cited Klayman's own precedent in its order, as plaintiffs should be well aware the defendant's failure to investigate and poor journalistic standards is insufficient to establish actual malice. And again, accordingly, plaintiff fails to state a cause of action as to all 3 counts in his complaint to the failure to properly allege actual malice. Then, Your Honor said, standing alone, the alleged defamatory statements are pure opinion or rhetorical hyperbole. This has not changed. These statements that are the exact same from complaint to complaint to complaint. They still remain pure opinion and rhetorical hyperbole. The court went into reasoned analysis about that and ultimately said defendant statements do not present an actual basis for claims of defamation based because they are protected statements of pure opinion or rhetorical hyperbole. Protected statements. First Amendment. That's super important. Your order was clear. It dismissed the complaint, as we said, otherwise it would be closed. The case was prematurely appealed. The appeal was dismissed, remanded back. No motion for rehearing or reconsideration was ever filed. That's super important. At the last hearing, Your Honor, Mr. Klayman repeatedly talked about the court's error and how he essentially wanted rehearing and the court had discretion. The court lost discretion under the rules of procedure. The court repeatedly told Mr. Klayman, are you trying for a rehearing again? That's not the case. And so what we have here, Your Honor, is a rehearing without a rehearing. He's filed the same or similar complaint, hoping for a different result. it's offensive weaponized litigation. We still don't have discovery. We've been in this 2 years. So on August 25th or August 26th, we got a complaint the day before at like 4 o'clock, which Your Honor ruled was the operative complaint. Then after your hearing, there was a corrected version of that, another version of that, which would probably be the third complaint filed in this. Under 1.190, there was no leave, there was no consent, and so the third complaint is actually due to be stricken just as a nullity at this point because of, once again, lack of following Florida rules of procedure. Mr. Klayman is, of course, welcome to file an appeal after judgment, but filing the same complaint to get a reconsideration is offensive and abusive process. Your Honor can look at the complaint for defamation and the amended complaint for defamation and see they're almost the exact same. We kind of ran it into one of the plagiarism apps, and it said like it was 95 or 97% the same. He's added a couple little lines in there that this is a clear factual question to again try to get Your Honor to reconsider your prior ruling, which is res judicata on this case. The court was clear. We've gone through that. This is the plight of those sued by Larry Klayman. It's a waste of resources. It's not offensive. I'm not trying to be offensive. I'm not trying to attack him. It's just the fact that this is what people deal with when you dare say something under the First Amendment by Mr. Klayman about Mr. Klayman. You've got to hire lawyers and litigate for 2 years. So issue one, for Your Honor is you've ruled on this complaint. Your Honor can rule again on the issue the same order. I don't even think you have discretion to reconsider your order at this point, nor do I think you would, because you issued a reasoned order. Part two is the second motion we filed, which is under 770.01. So 770.01 is a condition precedent. It is required in defamation cases to be filed noticed in the complaint that the plaintiff complied with 770.01. That requires notice in writing on the defendant specifying the article or broadcast and the statements therein which he alleges to be false or defamatory. 770 specifically talks about newspapers, periodicals, and was amended to other medium as the internet became popular. Klayman responded saying, "Oh, Wonkette's not media. It's not a publication. It's, in his words, a pornographic rag or communist blog." Well, his opinion doesn't matter, and look no further than what he originally said. Klayman pled Wonkette is a publication, and it publishes news commentary. End of analysis. So under 770, he served no notice. He chose Florida State Court. Wonkette's unquestionably a website of public interest, which publishes news. I go through the legislative history of the purpose of it briefly. It was established to give entities like under the First Amendment, media, the chance to pull something back if it went too far, if one of its writers went too far, to afford to newspapers, back in 1950, so we only were dealing with newspapers, afford to newspapers and periodicals an opportunity in every case to make a fair retraction and mitigation. Well, Your Honor's ruled that there was no need for a mitigation or retraction in this instance, but even then, even if we didn't have to get that far, 770 would have required a pre-suit notice of all this served on the defendants. It was ultimately amended, as we discussed, to talk about other mediums. 2014, it went from radio and television broadcasts. The law is clear. 2000, it specifically went even to internet message boards, which is even more broad than a blog. But the case law is clear. This would have required 770 notice. So where are we with that? So, the remedy generally is dismissal without prejudice. The problem is it's been 2 years since these were published, and so the statute of limitations in Florida have run. So you got a complaint that was dismissed by Your Honor without prejudice in an attempt that if he could possibly find something else to allege, maybe he could. He didn't. So that's a problem. So 2, 770 notice fails and the statute of limitations is run. And then we have number 3, which we brought up in our initial pleading, which is the strategic lawsuit against public participation defense. This court has determined this was free speech, that this was protected speech. And so under 768295, this case is due for review to be expeditiously disposed, and defendants are entitled to recover attorney's fees. We also have a proposal for settlement that we think we can entitle attorney's fees, which we can address at a later time. But 76828 is exactly what this was is about. It's a strategic lawsuit designed to either weaponize litigation and run out attorney's fees, or get somebody to retract something that's probably protected just so that you don't have attorney's fees. And public participation, he can call it pornographic or communist or whatever he wants, whatever his tagline of the day is, to make it political, but it's political speech, it's protected speech, it's as this court ruled, rhetorical hyperbole. So in conclusion, the complaint was properly dismissed. There's an order, this res judicata of the case. A carbon copy complaint has been filed. Another complaint was filed after that without leave of court. Again, just Larry Klayman rules of civil procedure is what we've been dealing with here. It's inappropriate and harassment. Frankly, Your Honor could refer this to the Florida bar. In addition to being legally incapable of stating a cause of action here, no notice was served under 770. That's fatal. And then under SLAPF law, it's also fatal because this is the exact type case that's a strategic lawsuit against public participation. And we'd request dismissal with prejudice, Your Honor.
Right, Mr. Klayman.
Your Honor, quite apart from saying that he's not making personal attacks, obviously, counsel is. Okay, and let's back up here because the recitation of what occurred here is inaccurate, and I would respectfully request that you take a look at the record. Number one, there's no dispute in terms of the pleadings that are filed, and the operative complaint here is the corrected amended complaint. All we did was correct an amended complaint. There was an error in it, so we just simply corrected it so it's not a third complaint. Okay, that's a false statement. Number two, as we allege, the statements that were made that were defamatory are statements of fact. I was accused of sexual harassment. I was accused and published that I'm a grifter, which means I'm a thief. You can see the pleadings that we filed recently, which set forth the Webster's definition. Grifter is someone who steals. He's a thief. And then I was accused of stalking a woman. Okay, these are all factual statements, Your Honor. So, Your Honor, there was no contest in the last pleadings that were filed by the defendants that this was in fact not defamatory. It clearly is defamatory. And whatever Your Honor may have ruled before, you have the right, because you're a judge of integrity, to go back and take a look at this and say, hey, I made a mistake. This is not just opinion, it's fact. And consequently, this was a well-brought complaint. The case has gone on for 2 years. They have not, and I'll go in reverse here, raised 770 for 2 years. Under Florida Rules of Civil Procedure 1.120C, they've waived any claim to 770. And that rule says, by failing to timely and specifically raise the issue in the pleadings, a defendant waives the argument that a claimant did not meet a condition precedent. Okay, so they've waited 2 years. They did that intentionally because they wanted the statute of limitations to run. Clever, but no cigar, Your Honor. I mean, that's not honest pleading. It's not proper practice. They've waived the 770 argument. But even more importantly, this is not a publication that amounts to legitimate media. Let me read you a couple seminal landmark Florida cases on this. This is a smear job. Yes, they're admittedly communists. This commie girl industries. They really despise me because I'm a conservative lawyer. I'm an activist. I founded Judicial Watch and Freedom Watch. They've had it in for me for a very long time. But this isn't legitimate news. They don't qualify under 770. The kinds of articles that they write, let me just quote some of them. It's in our last filing. Quote, this is the title, "Judge who probably has vagina teeth defeats poor super lawyer Larry Klayman again." Another one, "Roger Stone on Gab offering to sperm up Laura Loomer. Laura's my client. Sorry to hear about your breakfast." 3, Josh Hawley, pure surely MAGA brothers watch porn all day because liberals hurt their fees. This is the kind of stuff that they publish, okay? It's not news. And Your Honor, take a look at these cases when you have time. If you haven't had time, I know you're busy. But let me just read to you these 2 landmark Florida cases about what constitutes legitimate news. First one is Trujillo, Trujillo versus Banco Center del Ecuador, 17 F Supp, 2nd, 1334, 1338, Southern District of Florida, 1998. Quote, "By definition, all news media disseminates information, but it is a syllogism to conclude that all those who disseminate information automatically qualify as news media. The function of the media is to inform and to initiate uninhibited, robust, and wide open debate on public issues." And then the court goes on to say, "False, intentionally misleading, or defamatory publications have no essential part of any exposition of ideas and are of such slight social value as to step to truth that any benefit that may derive from them is clearly outweighed by the social interest in order and morality." Florida courts have refused to define parties making defamatory statements later reported by news outlets as media in and of themselves. That's crucial, Your Honor. This is not legitimate media. It's not legitimate public debate to be smearing people over vaginas, over pornography, over penises, notwithstanding the fact that they defamed me with statements of fact. And of course, you know that malice, actual malice, is that which is false or reckless disregard for the truth. They never did any background to check anything out. They just wanted to smear me in their zeal with their ideological hatred of what I do and people like me do. Then, in another case, Comins, Comins versus Van Voorhis, Vanvoorhis, 135 Southern 3rd, 545, Florida District Court of Appeals, 214. The court expressly wrote, this is a state Florida appellate court, quote, "We are not prepared to say that all blogs and bloggers would qualify for the protection of 770-01. The blog was entitled Public Intellectual, and its founder testified that he used it to, quote, publicly comment on issues of public concern in an intellectual manner without tying my comments to my professional identity," unquote. Okay, so that in conjunction with Trujillo, you see, in that case, that was a legitimate blog. This is not legitimate because it's not dealing with truth. It's dealing with defamation. It's dealing with smearing people. It's borderline pornographic, and it's not legitimate news. So 770 wouldn't apply. But again, they waited 2 years to assert this as an affirmative defense. They've lost that affirmative defense under Florida Civil Procedure 1.120, which says, by failing to timely and specifically raise the issue in the pleadings, a defendant waives the arguments that a claim did not meet a condition preceding. They had an opportunity to do that in their initial motion to dismiss, and in their motion for judgment on the pleadings, they didn't. They hung back. They played a game with not just me, but with the court. And it is really offensive to be attacking me personally when I'm the one who was defamed. I'm the one, and there are more articles besides this, but this was the most egregious. To accuse someone of sexual harassment, as I'm sure Your Honor can understand, to accuse them of being a grifter, a criminal, a thief, to say that I stalk women, that's factual, that's not opinion, Your Honor. And that's what they did. So consequently, their motion should be denied. The case should go to discovery, and they can prove whether or not they qualify for actual malice with regard to making a false statement or reckless disregard for the truth. They really don't care about the truth. They just feed red meat to their communist readership, okay? And again, it's not a question of what my ideology is or their ideology is, but the fact is they do have a significant malicious hatred of me and people like me, whether it's Larry Klayman, whether it's Senator Josh Hawley, whether it's Roger Stone, whether it's Laura Loomer, my client, and the pornographic vulgar language that's being used in the smears without any effort to determine whether it's true or not does not qualify them as a media organization, even if they had timely raised the issue of Section 70. And last but not least, they've had notice for now going on 2 years. In fact, it's 2 years. They could have retracted. They had constructive notice of what happened. They didn't. They wanted to press ahead. So this is where we are today, Your Honor. I respectfully request that you look carefully at the pleadings if you hadn't had an opportunity. It's been a busy period. People are sick with COVID and everything else. I hope you're not. But take a look at this and you'll see that what I said just makes sense and comports with the law of Florida. Thank you.
Your Honor, briefly,
Right. Yes.
I can't imagine what judges would do in this state and in this country if you could file a complaint, get an order granting dismissal, and then refile the same complaint masquerading as a rehearing. And that's where we are. Mr. Klayman didn't like your order and is now trying to get a rehearing on it, and it's so inappropriate. 770 is required to be alleged in his complaint. So therefore, if it's not alleged in his complaint, the cases he cites are related to sovereign immunity or medical malpractice. It's completely distinguishable. 770 is a Florida statute. It is very self-evident. It does apply here, and I just Your Honor has ruled on this. The ruling should, if Mr. Klayman wants to appeal, be appealed. But asking Your Honor for a backdoor rehearing by filing the same pleading, and then filing another one which was substantially different, which no matter how many words you put corrected on it, it doesn't make it not a third complaint. It's just we're at 2 years, and certainly COVID's been in there, and Your Honor's exhaustive resources, but Your Honor's spent time on an order. That order should govern the case, and this case should be off to the appellate land.
Your Honor, if I may respond briefly.
Go ahead.
Yeah, first of all, Your Honor gave us leave to file a complaint, so we didn't go ahead and do this, on our own. So that's inaccurate and false. Number two, they did hang back. They could have raised this earlier in their pleadings. They didn't. They waived it at this point in time. Number three, it's not a legitimate news source which actually furthers public debate, as the Florida courts have held. It's simply a communist rag that attacks people because they don't like them ideologically and then defames them and doesn't even do the due diligence to find out if what they said is true or not. It doesn't matter. So, Your Honor, this is a valid case, and you can try to package it as you want, but Your Honor's an honest man, and I know that you'll take a look at this again. And the corrected amended complaint pointed out what were the factual statements that were made. It wasn't just opinion. So I asked Your Honor respectfully go back and take a look at this, and it would be a grave injustice to dismiss this action. Thank you.
All right. I'll look at everything again, but Mr. Phillips, so why is, and Mr. Klayman's argument is, as far as the 770 issue, I guess he's saying that should have been raised in your initial motion to dismiss or earlier directed to the original complaint and waived not doing that.
We can provide an additional case law, Your Honor, but the case law is clear that this isn't, the requirement is not on defendants to bring that up. And it's on plaintiffs to abide by the statute. If you break the law, you break the law. It doesn't matter that the defendants, tell you oh, by the way, you broke the law. The fact is this complaint needed to be preceded by a notice, and in that complaint, notice was required. I can provide additional case law to Your Honor.
And as far as an order, you all can tell me, do you want a separate order on each of the motions? Do you want to address them in one order?
Your Honor can address them in one order.
You all right with that? Okay.
Yes, sir.
Yeah, sure.
Okay.
But I would say,
go ahead.
The only motion that's in front of you right now is the recent one they filed on 770. I mean, this is all, the other stuff all preceded the filing of the corrected amended complaint.
The plaintiff's motion to strike and or dismiss the amended complaint was filed September 8th. And I think it references both the amended complaint and the corrected amended complaint. Let's see where we are.
We filed essentially two motions to dismiss. They're meant to be cumulative, not.
Yeah, they're different issues. I think, if I understood what you're trying to say, Mr. Klayman, is that the motion to dismiss, motion to strike and or motion to dismiss the amended complaint was filed before your corrected amended complaint?
Filed after.
Yeah, it's filed after. So I think it addresses the amended complaint and the corrected amended complaint.
Well, whatever it addresses, Your Honor. But in any event, those are the only operative pleadings, okay? After the amended corrected complaint, they're the only operative ones.
There's two of them, two motions.
Yeah, to the extent that's the case, I didn't go back and check this morning, and that may be the case.
Yeah, I believe so. That's the way I look at it. And it mentions the motion to strike and or motion to dismiss plaintiff's amended complaint also references the corrected amended complaint. So I'm agreeing it's addressing that as well.
It's essentially the same complaint. It's just a corrected complaint. We pointed out to you with specificity what were the factual defamatory statements.
Right. And the other motion is the motion to dismiss the corrected amended complaint based on Florida Statute Section 770.01. So I'll address both of those motions in one order. And I guess, Mr. Phillips, it was your motions. So if you can prepare a proposed order in Word, and then I can work with it.
Yes, Your Honor.
Change it.
I would like to be able to comment on that order. Obviously, I will disagree with what Mr. Phillips prepares.
You can, or you can prepare.
I'll prepare my own order. Yeah,
you can have competing orders. That's fine.
Yeah.
It's probably best to try to set a time to when to submit those, so we at least know. And it's up to you how much time you all want to prepare your proposed order.
10 days, Your Honor.
30 days, Your Honor.
Your Honor, we're entitled to expedited on this. We would request 10 days. It's taken too long as it is.
I've got one assistant and one associate. My assistant has COVID. The office is sick. It's depleted, so we'd ask respectfully for 30 days.
All right, I'll allow 30 days. I know some involved issues. So let's get a date, just so we all know.
Okay, well, I guess I haven't looked at the calendar, but I guess it would be, what is today, the 4th? So it would be February 4th. If that comes out during the week, let me see.
I'm not sure. Or February 3rd, if y'all want to.
Yeah.
I believe February 4th is a Friday. It's actually my birthday,
Okay.
so I won't forget
4th.
it.
Well, we'll give you a birthday present, Mr. Phillips.
There you go. Thank you. Can't wait.
All right, February 4th, I'll be looking for them. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. Good luck to you all.
Thank you. Bye.
Good health.
You too.